What is a contempt hearing? So in Florida divorce and family law, contempt and enforcement matters come up pretty regularly. Not every case, definitely not every case, okay? But this is usually for after the divorce or the paternity case or child support case is over with. Somebody will file to enforce or hold somebody in contempt. Can be dealt with, or done during the actual initial proceeding. So during the divorce, if somebody is in contempt of a court order or enforcing an agreement of the parties, if there's no court order on it yet, or if, again, some issues cannot be, contempt is not an appropriate remedy for certain issues within Florida law. Not the scope of this informational video. Basically what we're talking about is contempt in the context of somebody's filed a motion for contempt against you and you want to know what to do at this point. Number one is obviously read the motion for contempt and to try to determine why the other side is saying that you are in contempt. So if you are in contempt, again, you need to speak with an attorney about this, and you need to, understand what can happen now that you haven't filed a court order. And basically, emotional contempt is basically saying that you didn't file a court order, therefore the court, should put you in jail or fine you or take away your time sharing if it's a time sharing issue, or grant fees to the other side because they had to go and try to enforce something. There's a lot of different remedies. Passports being, frozen, basically. Tax refunds being intercepted. There's a whole list of different things that are available. Again, not for every case, and it's not ordered in every case. It's just there's a whole bunch of different things. Obviously, jail and incarceration, and basically a writ of bodily attachment, which kind of like a warrant, for your arrest, usually is the one that scares most people and that we get the most questions about. We've done both sides of it, filing motions for contempt and enforcement, and then also responding, from the respondent's side of a motion for contempt and enforcement. And sometimes, let's say an alimony situation, and there's a motion for contempt filed for non-payment alimony. Maybe it was, going to another address, or, maybe the person lost their job and, they're filing now for modification. There's other things out there that, sometimes we need to peel back the layers and look at this. But at the end of the day, just not doing something and saying, well, I lost my job or I couldn't really afford it anymore, is not the way to go. You need to, there needs to be something filed, because right now you have a court order, and that's what we're taking this hypothetical situation from in this informational video, is that there's a court order that says you need to do something and you didn't do it. So if you didn't do it, again, that's why you need to speak with an attorney to figure out what can happen in your case, what the judge can do, if there's ways to remedy the fact that you didn't follow it. And sometimes these things can be worked out, settled, and not every case. Sometimes it does need to go before a judge. But ideally, if you have children with the other side, a lot of times people do want to try to work on the situation to try to, move things forward. But if it's been non-payment of child support for 8 years, sometimes that's the only choice, is to move forward with some type of motion for contempt and, move forward with these types of remedies, so that way that the person that should be receiving the support is actually receiving it. So we've done all different types of it. And again, this is solely a video about Florida divorce and family law related, contempt and enforcement. So we've dealt with many of the cases dealing with Florida Department of Revenue, child support enforcement arm of Department of Revenue, which a lot of times will file, actions, on the behalf of the obligee, the person that's supposed to be receiving it, especially if they're receiving some form of state aid or for whatever other reasons that they're within the case. And there's also modifications. There's administrative support orders as well, or another part of probably for a whole other video within the child support context. So all these different things and all these different court orders sometimes do need to be enforced at some point. And so there's a method, and there's things that are supposed to be done, to follow along to make sure that it's the enforcement process is going appropriately. And then again, one of the options there that the court has at their disposal is holding somebody in contempt and using the different parts of Florida law to that are at their disposal to basically compel the person to make sure that they're abiding by the law, and that the contemptuous action that either by non-payment or whatever was not willful. They weren't just doing it just to basically say that I don't care that I have a court order, I don't care that a judge has told me what to do, or I agreed and then it was ordered. Again, the courts take these things seriously, and our advice is always going to be follow your court order. So you need to follow your court order, and if the other person's not following it, then that's where people come in to file for a motion for enforcement or contempt. And if the court order is not being filed, again, there needs to be a response, and you need to obviously defend yourself, because there are things that are pretty serious that can happen during the course of these types of proceedings. So this has been a little bit of information about contempt in Florida.